Coming up, when the prosecutor says, in light of Ms. Vito's and Mr. Wilbur's testimony, the state would like to dismiss all charges. Imagine if Judge Chamberlain Holler had responded, not so quick. I'm going to ask a bunch of interested political groups whether they want to file amicus briefs about whether the charges really should be dismissed, and then appoint a retired judge to develop arguments why they shouldn't be dismissed. If you were watching the movie and that happened, your response would probably be, what the hell? And that was exactly my response when I heard what Judge Emmett Sullivan had done. Welcome back to Political Spirits. I'm your host, Franklin Rye. We still stand for the proposition that the left and the right should have a few drinks and talk. Compromise is not a requirement. If those discussions result in us changing or even abandoning our positions, that's fine. If they don't, that's fine too. We just need to talk to each other. In that way, we can unify through speech. And if the discussion becomes a bit heated, at the end of the night, we should still be able to split up the bar tab and be on our way. So what are we going to talk about this week? Well, in the last couple of weeks, 3 things have happened in the courts that have caught my attention, and one of them received a great deal of attention on a national level. In a way, they're connected. One of them involved a state case in a federal court that I've been following and have commented on, and the other involves a federal prosecution that we've all been following. What has happened with the judges in those 2 cases reminds me just how far the judiciary has degenerated in this country, and it's left me frustrated, even angry, as I've read the coverage of the judges' actions and decisions. The third case was a Supreme Court decision, and it didn't receive that much attention for a Supreme Court decision, but it helped to restore my belief in the judiciary, our country, and our system of government. In the end, it is my hope and belief that the other 2 cases will ultimately be resolved as logically, ethically, and justly as that case in the Supreme Court. So what cases am I talking about? The first one I discussed in episode 81. It's the case out of Connecticut in a federal district court where 2 plaintiffs are challenging the Connecticut state rules that allow biological males who identify as females to compete against girls in women's sports. In this instance, girls' high school track. In that case, incredibly, the judge directed the plaintiff's counsel with a not-so-veiled threat of judicial action against him if he failed to comply, that he must refer to the biological males who have dominated girls' high school track sprint events in that state as, quote, transgender females, close quote. As the Hartford Courant notes in its coverage of May 12, 2020, the plaintiff's counsel has referred to the athletes as, quote, males, close quote, or, quote, biological males, close quote, throughout the proceedings. The judge, Robert N. Chatigny, admonished them that that was not accurate to refer to them as male and that they are to refer to them as, quote, transgender females, close quote. According to the judge, that they are females is, quote, consistent with science, common practice, and perhaps human decency, close quote. The plaintiffs contend that the judge's statements show that he has prejudged the case and that they are, quote, inconsistent with the appearance of impartiality, close quote. I couldn't agree more. When you have a case in which the plaintiff's argument is that biological males should not be allowed to compete against biological females in high school girls' sports because the biological males have an unfair physical advantage, what else could a plaintiff think when the judge says it is consistent with science to refer to biological males using the term female, and that to refer to them as male is not only not consistent with science, but may be inconsistent with human decency? At that point, as the plaintiff, you have to think the case is already lost and the trial hasn't even commenced. Not surprisingly, in response, the plaintiff has filed a motion for the judge to recuse himself. Do I think he will? No. I think he'll continue to preside over the case, that it's quite likely it'll be decided against the plaintiffs and in favor of the state, and that the ultimate decision will be rendered on appeal. Should it have to go that far? Absolutely not. As I explained in episode 81, the state of Connecticut's policy is absurd, and it is in fact fundamentally opposed to the biology of sports performance. The judge's insistence on politically correct language is just the latest piece of evidence that political correctness is gradually destroying much of our society. There's nothing wrong with the judge believing that a biological male that identifies as a female should be referred to as a transgender female out of a general sense of common courtesy. To elevate that to a courtroom mandate in a case that involves the question of whether, for purposes of athletic competition, individuals who are biologically male can be allowed to compete in female sports is so fundamentally unfair to the litigants that no fair-minded member of the judiciary would ever issue such a mandate. Think I'm overreacting? Get a load of this statement from the judge. Quote, "This isn't a case involving males who've decided that they want to run in girls' events. This is a case about girls who say that transgendered girls should not be allowed to run in girls' events. So going forward, we will not refer to the proposed interveners as, quote, males, close quote. Understood? Close quote." Think about that. Among other things, the plaintiffs contend, as does the U.S. Department of Justice, that the Connecticut rules violate the Title IX protections of women's sports. If you can't make your argument that the athletes in question that have been dominating girls' track sprint events are biological males, then the judge has in essence announced that he's already rejected your case. Perhaps some out there still think I'm overreacting. Well, check out this language from the judge. Quote, "So if you feel strongly that you and your clients have a right to refer to these individuals as, quote, males, close quote, and that you therefore do not want to comply with my order, then that's unfortunate. But I'll give you some time to think about it, or you can let me know if it's a problem. If it is, gosh, maybe we'll need to do something. I don't want to bully you, but at the same time, I don't want you to be bullying anybody else." Close quote. Did you get that? He's threatening to hold counsel in contempt if he continues to refer to the biologically male track athletes as biological males. Indeed, he contends that the plaintiff's attorney doing so is bullying the biologically male track athletes. This is one of those moments when you realize that the political correctness and the virtue signaling and the acceptance only of the views of the left by the elites with the amplified voices have so polluted our institutions that it threatens their very ability to function. I haven't mentioned it, but you're probably wondering, so here it is. Judge Titigny was nominated by President Clinton. Are you surprised? I'm not. So what's the next case in the last couple of weeks that has left me frustrated and angry and worried that our governmental institutions are crumbling? You guessed it, the decision of Judge Emmett Sullivan in the prosecution of retired General Michael Flynn to allow amicus filings by multiple parties to argue against the Department of Justice's decision to drop the charges against General Flynn. And perhaps even more incredibly, the decision of the judge to name a retired judge to challenge the department's decision to drop the case. And apparently the retired judge is also going to consider whether General Flynn committed perjury by changing his mind on pleading guilty to the charges after he previously admitted them in court. What makes this last element so incredibly absurd is that the Department of Justice has concluded that the interview which was the subject of the case should never have occurred because there was no legitimate investigative purpose for it to have occurred. The decision to drop the charges came soon after internal Department of Justice notes were finally released to Flynn's counsel, in which the Department of Justice attorneys pursuing the interview were discussing what their goals were, and two of those discussed included, quote, getting him to lie so they could prosecute him or get him fired, close quote. These were Obama administration holdovers, including Peter Strzok, who was so driven by anti-Trump venom that when his emails revealing his overwhelming animosity towards President Trump were released, he was thrown off the Mueller investigation. Make no mistake about it, the Department of Justice moved to dismiss the charges against General Flynn with prejudice, to dismiss them permanently, and in so doing they acknowledged departmental misconduct. They acknowledged that because the interview never should have occurred, the charges never should have been filed. The prosecution is saying that the charges should never have been filed, and the judge is fighting them. Think about that. You want a humorous pop culture reference? Think about the end of the movie, one of my favorite movies, in fact, My Cousin Vinny, when the prosecutor says, in light of Ms. Vito's and Mr. Wilbur's testimony, the state would like to dismiss all charges. Imagine if Judge Chamberlain Holler had responded, not so quick. I'm going to ask a bunch of interested political groups whether they want to file amicus briefs about whether the charges really should be dismissed, and then appoint a retired judge to develop arguments why they shouldn't be dismissed. If you were watching the movie and that happened, your response would probably be, "What the hell?" And that was exactly my response when I read what Judge Emmett Sullivan had done. And incidentally, I probably shouldn't have been that surprised, given that Judge Sullivan is actually on the record asking prosecutors from Special Counsel Mueller's office whether General Flynn should be charged with treason. For a member of the judiciary to ask such a question doesn't just call into question whether his consideration of the case is unbiased, it also calls into question his competence. Treason is thrown around in casual conversations referring to any conduct that we think is disloyal to the country. But it's actually a crime which is expressly defined in the Constitution, so that it wouldn't be charged willy-nilly. It consists of, quote, levying war, close quote, against the United States or providing, quote, aid and comfort, close quote, to an enemy of the United States. And the Constitution also mandates that very specific evidentiary requirements be met. And treason is punishable by death. By showing his apparent ignorance of those facts in court, the judge made it look like he'd been spending his time watching Rachel Maddow rather than refreshing his understanding of the Constitution. So I guess I shouldn't have been surprised. Michael Flynn was a disruptor. In the Obama administration, he aggressively pressed his concerns about the rising power of al-Qaeda, as much of the administration failed to recognize the threat it represented. He was also a vigorous opponent of the Iran nuclear deal. President Obama held such a low opinion of Flynn, perhaps because of his vigorous disagreements with some of President Obama's policy opinions, that President Obama specifically cautioned incoming President Trump that General Flynn was not someone to be trusted. Then President Trump named General Flynn to be his national security advisor. The resistance against President Trump has run deep and wide. I'm not saying that Judge Sullivan is part of that resistance, but I am saying that Judge Sullivan's decisions, his decisions after the Department of Justice notified him that they wanted the charges against Flynn dismissed permanently, have been so bizarre that it makes you wonder. And that alone is reason enough that Judge Sullivan should rescind his prior orders and disallow amicus briefs, especially given that he previously ruled that they couldn't be filed in support of General Flynn, and also rescind his order naming the retired federal judge to present arguments against dismissing the charges. I'm not saying that he should shake the hand of Flynn's attorney Sidney Powell outside the courthouse and, like Judge Chamberlain Holler and My Cousin Vinny, say, "You're one hell of a trial attorney." He should just dismiss the charges. And it's the third case, the one that restores my faith in our justice system, that makes it all the more apparent that Judge Sullivan should grant the motion of the Department of Justice and dismiss the charges and rescind his orders allowing amicus briefs and naming the retired judge to make arguments against dismissing the charges. That case is United States versus Shinanang Smith, and the Supreme Court ruling was unanimous, and it was expressed in an opinion written by perhaps the court's most liberal justice, or at least its most well-known liberal justice, Ruth Bader Ginsburg. And that ruling overturned a decision of the Ninth Circuit Court of Appeals, traditionally the most liberal circuit in the country, and it did so in the form of a full-on smackdown from Ruth Bader Ginsburg, a finding that the Ninth Circuit Court of Appeals had abused its discretion. Think about that. In today's polarized environment, the Supreme Court rendered a unanimous decision, and the opinion was written by its most well-known, very liberal justice, and it lambasted the most liberal appellate court in the country, which incidentally is based in San Francisco, perhaps the most liberal big city in the country. So now you see why the decision encourages me. But it's not just relevant because it's a potential antidote to the two other cases that I referenced. It's also very relevant to the Flynn case and the most recent conduct of Judge Sullivan. You see, the defendant in United States v. Shinanang Smith was an immigrant consultant who assisted immigrants who were working in the U.S. illegally. She collected approximately $6,000 per client for a total of $3.3 million, knowing that the work program she was telling her clients to pursue no longer covered them because the application deadlines had long since passed. She was prosecuted for violating a law making it a felony, quote, to encourage or induce an alien to come to, enter, or reside in the United States, knowing or in reckless disregard of the fact that such coming to, entry, or residence is or will be in violation of the law, close quote. The law also provided enhanced penalties for doing so for the purpose of financial gain. The defendant argued that the law violated her First Amendment free speech rights, and the case ended up in the Ninth Circuit Court of Appeals, as I noted, historically the most liberal federal appellate court in the country. When the case reached the Ninth Circuit, rather than simply considering the arguments presented by the prosecution and the defense, the appellate court chose to invite 3 advocacy groups to file amicus briefs in the court arguing particular points. The court chose the Federal Defender Organizations of the Ninth Circuit as a group, the Immigrant Defense Project, and the National Immigration Project of the National Lawyers Guild. And then the court told them what to argue. They told those organizations precisely the constitutional arguments they wanted them to make, that the statute which the defendant had been convicted of violating was unconstitutional. They turned the judicial process on its head. The parties in a case hire their attorneys and they make their arguments. If the party that loses at trial appeals the decision, the appellate court considers the arguments made in the trial court. But apparently that wasn't good enough for the Ninth Circuit. You don't have to be in a very cynical mood to conclude that the Ninth Circuit wanted to overturn the law in question, but didn't think they could do so based on the arguments made by the defendant's counsel at trial, and in the Ninth Circuit on appeal for that matter. Incidentally, as the Supreme Court noted in its opinion, there is no argument that the defendants didn't have competent counsel. What does this remind you of? I know what it reminds me of. It reminds me of what Judge Sullivan did in the General Flynn case. Rather than dealing with the arguments made by the parties, most importantly, the decision by the Department of Justice that its own prosecutors acted improperly with no reason to conduct the interview of Flynn to begin with, and therefore the charges should be dismissed, Judge Sullivan has gone in search of other arguments through amicus filings and a retired judge. So what happened after the Shinanang Smith case reached the Supreme Court? Well, the Ninth Circuit received what can best be described as the judicial equivalent of corporal punishment. They received a public judicial paddling from a unanimous Supreme Court, incredibly through an opinion written by the diminutive, extremely liberal, and apparently indestructible Ruth Bader Ginsburg. When I read the opinion, I had humorous visions of Justice Ginsburg, who looks like a cross between Edna Mode from The Incredibles and television sex therapist Dr. Ruth Westheimer, wielding a wooden paddle from the days when American teachers would actually dole out spankings in the hallways of elementary schools. That's probably going to sound strange when you listen to this episode, but what the heck. The basis for the Supreme Court overturning the Ninth Circuit decision and sending the case back to the appellate court for reconsideration was that the appellate court had engaged in an abuse of discretion. The court noted that the American justice system relies on the parties to frame the issues and for the courts to render their decision based on the parties' presentations of those issues. That isn't what the Ninth Circuit did. And as Justice Ginsburg wrote, quote, "No extraordinary circumstances justify the panel's takeover of the appeal," close quote. She went further, quote, "A court is not hidebound by counsel's precise arguments, but the Ninth Circuit's radical transformation of this case goes well beyond the pale," close quote. She and the rest of the unanimous Supreme Court sent the case back to the Ninth Circuit for them to consider the case once again, and expressly ruled that in their reconsideration the case is to be, quote, "shorn of the overbreadth inquiry interjected by the appellate panel and bearing a fair resemblance to the case shaped by the parties," close quote. With all the legal terminology, it may not look like it, but that's a judicial smackdown. By the way, the Supreme Court decision came down within a week before Judge Sullivan made his bizarre rulings in the Flynn case. So does this mean that Judge Sullivan's game playing in the Flynn case will end up being struck down? There are, of course, no guarantees, but it gives me hope. And the unanimous Supreme Court decision sharply rebuking judicial overreach from the left gives me even more hope that our system of government, including its justice system, is more resilient than I had feared. You know what else is resilient? This podcast. You can count on it every week. We'll continue that resilience next week with another episode of Political Spirits. Be sure to tell your friends about Political Spirits and like the podcast on Facebook at Political Spirits. And follow me and the podcast on Twitter at Franklin Rye. And remember, all episodes are now on YouTube as well. And the YouTube channel is named Political Spirits Network. If you're watching on YouTube, be sure to like and subscribe and hit the notification bell and select all after you hit the bell. This is Franklin Rye. Thank you for listening.